Okay, let's unpack this. Today, we're taking a deep dive into what is, well, arguably one of the most comprehensive, maybe even aggressive, legal frameworks for public integrity out there. We're talking about the organic law on the duties and responsibilities of leadership. And just so everyone's clear, we are focusing on the framework established in Papua New Guinea, PNG.
Right, and that jurisdiction is really key here. This isn't your standard ethics code. It's basically a constitutional level tool, really designed for maximum enforcement. Our mission, really, is to break down exactly how this law dictates the public, professional, and, importantly, the private financial lives of constitutional office holders.
Yeah.
We need to focus on those very specific, stringent rules aimed at stamping out not just actual corruption, but even the potential or maybe just the appearance of conflicts of interest.
And what jumps out immediately, I think, is just how wide this net is cast. It doesn't just focus on a leader, the official themselves. It, sweeps in almost everyone around them. It creates this kind of almost like a corporate firewall around the person in office.
Exactly.
And to really get a handle on this law's power, we absolutely have to understand how it defines three key terms, and it defines them quite aggressively.
Absolutely essential. First, there's the person to whom this law applies. That part's fairly straightforward.
Yeah.
Top constitutional figures, prime minister, chief justice, people like that. But then it gets much more intricate with the term associate.
Okay, yeah, this is where it gets really interesting, isn't it? Because the definition of associate seems designed to capture, practical influence, not just some legal loophole. It covers the leader's family, their relatives, and any person, even an unincorporated profit-seeking group, associated with the leader, or, get this, associated with a member of their family or a relative.
That's the core insight right there. The law doesn't really care if you've technically separated your assets or put them in your cousin's name. It's about practical influence. If your spouse owns it, if your second cousin owns it, the public might see it as potentially linked to you, and so does the law. It treats it that way.
Right. And then the third term, benefit. It's also defined super broadly, seemingly to shut down even minor attempts at influence.
Yes. Benefit covers any gift, any loan, any service, whether there's money involved or not, and basically all other personal advantages or favors given that go beyond what you'd call normal standards of hospitality.
So we're not talking about a cup of coffee or maybe a quick lunch?
Probably not. But if a gift is worth more than, say, a basic promotional item, it's potentially under scrutiny. If it's outside that normal everyday pleasantry, it needs to be accounted for. It's a very low threshold.
Okay, so with those incredibly broad definitions setting the stage, let's dive straight into Section 1. This covers the mandatory transparency, the periodic statement of income, etc. This law essentially forces leaders to lay bare their entire financial picture and that of their immediate family regularly.
It's a system built on just total, relentless disclosure. Leaders have to provide this really comprehensive statement within 3 months of taking office, and then at least once a year after that. And it's not just a summary, it's a full inventory.
An inventory that demands separation, which I found fascinating. What exactly do they have to hand over to the Ombudsman Commission, the OC, which seems to be the anti-corruption watchdog at the heart of all this?
So the statement, it has to be provided separately for the leader, their spouse, and crucially, any of their children under voting age. They can't just lump all the family assets together.
Wait, hang on. Separate detailed statements for the leader and their minor children. That sounds like a almost impossible compliance burden. Is that actually enforceable, or is the sheer complexity maybe part of the deterrent?
I think it functions as both, really. The level of detail they ask for money, personal property, real estate they possess or control its design, so nothing slips through the cracks, even if an asset is technically in a child's name. They need to detail total income received and the source for every bit of income.
So the OC gets a complete map of every dollar coming in.
Exactly. They also need to list all business connections, including those tricky, unincorporated profit-seeking organizations you mentioned, directorships, offices held, all business deals, debts incurred or paid off during that period.
And what about gifts, since we just established how broadly benefit is defined?
Right. They have to disclose all gifts received, unless it's something received in the normal course of events from a close relative. And they have to state the value of those gifts. Even for, sundries and minor items, they need to show the general nature and roughly the value. The law is incredibly meticulous, chasing down even tiny potential avenues of influence.
That scope is just incredible. But how does the OC actually enforce this? Does the paperwork just pile up somewhere?
Oh, not at all. This is where the OC shifts from being just a data collector to an active auditor. The OC, or another relevant authority, can issue a written notice demanding the leader explain or provide more detail about any discrepancy, any omission, even those sort of vague sundries listed in the declaration. It's a really powerful, active audit function.
And the penalty for not complying or getting it wrong is immediate and sounds pretty severe.
It is. Failing to comply without a reasonable excuse or knowingly, recklessly, or even just negligently giving false, misleading, or incomplete information that itself is explicitly defined as misconduct in office.
Wow.
That's a major charge just for bad paperwork. It shows the law values radical transparency just as highly as ethical conduct itself.
Okay, so if the disclosure rules are kind of like the headlights showing the way, then the prohibitions we're about to discuss are the guardrails. They define exactly where a leader cannot steer. Let's move to Section 2, which gets into specific actions that constitute that really critical offense: misconduct in office. Starting with Section 5, misuse of position.
Section 5 tries to block even the ask for improper influence. A leader is barred from directly or indirectly asking for or accepting any benefit for themselves or an associate. Remember that wide definition if it relates to any action in their official duties, unless the law specifically allows it. It's a blanket ban on influence peddling or, soft bribery.
And that ban also covers just using the prestige of the title itself, right? The law says a leader can't use or even allow their name or official position to be used to benefit themselves or anyone else, unless it's strictly for official duties. So, no lending your high-ranking name to a friend's business venture.
Precisely. Then moving to the specific financial constraints. Section 6 deals with personal interest. If a leader or one of their associates has an interest in a matter the leader is officially dealing with, they must disclose the nature and extent of that interest. And they have to tell both the OC and the relevant authority.
Okay, disclosure is step one. But once they've disclosed it, can they still be involved?
Generally, no. Dealing with that matter after having such an interest is considered misconduct. The only ways around it are if they're forced by law, like in an urgent emergency situation, or if they get specific authorization after they've made the disclosure. Transparency is the only potential path, but the default is definitely separation.
I think maybe the clearest boundary is the rule on ministerial directorships in Section 7. This seems to shut down one of those classic routes for, let's say, post-political reward or influence.
It's like an iron curtain, really. Section 7 makes it absolutely clear. A minister or their spouse or their minor child cannot become or nominate someone to be a director of a company or a foreign enterprise. Doing so is misconduct. The exceptions are incredibly narrow.
And what are those exceptions?
Well, things like purely honorary roles, or if the directorship is held as a government nominee. But crucially, in that government nominee case, any financial benefit they receive has to be paid directly into the Consolidated Revenue Fund, the main government account.
Okay. So that stops the family from basically skimming off the top of a government entity or state-owned enterprise just for having a seat on the board. The money goes to the state, not into their personal bank account. That's actually a brilliant mechanism to make sure loyalty stays with the public interest.
It absolutely reinforces that the office is meant for public service, not personal enrichment. And that same kind of firewall thinking extends to passive investments, too, through Section 8 on shareholding.
How far does that go? Does it mean a leader can't own any stocks at all?
Well, they can, but the rules make it tricky. Holding shares or investments in any company or foreign enterprise that could reasonably create a conflict of interest is misconduct. Now, given how high up these leaders are, figuring out what reasonably creates a conflict is pretty subjective and potentially hard to navigate.
So it puts the burden on the leader to be extremely cautious, I imagine.
Exactly. The only way out is either getting prior written approval from the OC, which as we've seen is probably a high bar, or if they somehow acquire the shares unexpectedly, like through inheritance, and they're taking reasonable steps to get rid of them quickly. It's all designed to force a complete separation between their investment portfolio and their public duties.
And the law keeps pushing this strict separation into government contracts and outside employment too, doesn't it?
Yes, Sections 9 and 10. They prohibit the leader, their spouse, or their minor child from having a beneficial interest in government contracts or from taking on other paid employment unless they get that prior written approval from the OC first.
When would the OC actually grant approval for something like that? It sounds like a recipe for conflict.
The law is quite specific. Approval will be denied if the work involves a significant potential conflict, or if it looks like the leader used their official position to get the contract or the job in the first place. These clauses basically make government contracts totally off limits for the immediate family unless the OC is absolutely certain there's no conflict risk, which, again, seems like a very high standard to meet.
So stepping back a bit, the law basically creates this zone of absolute financial purity around the leader while they're in office. But let's circle back to that wide net of liability. What happens if an associate, a spouse, a relative, breaks these rules, maybe without the leader being directly involved?
This is Section 16, and it's really critical. If an act that would be misconduct if the leader did it is actually done by a spouse, relative, or associate, the leader themselves is personally guilty of misconduct if that act was done with the leader's consent, and that can be express or even just implied consent.
Okay.
Or, and this is key, if the leader could have reasonably disassociated himself from those actions but didn't.
Wow, that's a heavy burden of responsibility.
It is. This rule effectively says leaders can't just plead ignorance about their family's business dealings. If your spouse takes a huge contract that clearly relates to your ministerial portfolio, you have a duty to actively and probably publicly distance yourself from it. If you don't, the law assumes you implicitly consented, and you could be held liable for misconduct. The law demands leaders actively police the financial activities of their entire close circle.
That really shifts the focus, doesn't it? From just preventing individual bribery to proactively managing even the appearance of any conflict. Okay, let's turn now to Section 3, Oversight and Investigation. The Ombudsman Commission, the OC, it's clearly not just some advisory board. It's framed as an investigatory powerhouse.
It absolutely is. It's the designated independent integrity body, and its powers under Part 3 of the law are extensive. The OC investigates complaints, and importantly, any person can make a complaint. They don't need special standing. Plus, the OC can launch investigations entirely on its own initiative. They don't need a public scandal to break. They can start digging based purely on those financial disclosure statements we talked about.
And when they do investigate, their power to demand information sounds almost total.
It's pretty close. Section 21 gives them the authority to summon any person that explicitly includes the spouse and children of the person under investigation to force them to provide information and produce documents. This allows them to cut through potential claims of, say, spousal privilege or just ignorance, making sure the investigation can be truly thorough.
Sounds like an investigator's dream toolkit. But I did notice one significant carve-out, a limit on their access to certain information.
Yes, that's Section 22. It creates a unique political balancing act. The Prime Minister, but only after consulting with the Chief Ombudsman, can issue a certificate declaring that certain information is exempt from disclosure to the OC.
What kind of information?
Things related to national security, defense, international relations, or confidential cabinet deliberations, but only if revealing it would be injurious to the public interest.
That sounds like a potential loophole for politically sensitive stuff.
Yeah.
The law seems to be trying to balance the need for integrity against, well, state secrets.
It does try, but that requirement for consultation with the Chief Ombudsman is there to act as a check, to ensure it's not just a unilateral political decision to block an investigation.
Okay, so once the OC finishes its investigation, if they find evidence of wrongdoing, the enforcement measures kick in, and they sound genuinely dramatic, especially when it comes to assets.
Yeah, this is the power relating to prohibited interests under Section 24. The OC can formally declare specific interests, benefits, or property as prohibited. This is really the big hammer in their toolbox. If a leader or their associate gets hold of one of these prohibited items, the OC has the authority to order forfeiture.
Forfeiture. So
Yeah.
the state can actually seize assets that were acquired improperly.
Yes. The OC can order the property be put into a trust or disposed of in some other way. This is crucial because it allows the state to directly take away illegal wealth, stopping people from keeping the profits of misconduct. There is a protection built in, though.
Oh.
If the OC thinks someone would suffer substantial loss because of the forfeiture order, maybe an innocent third party involved somehow, the order has to include provisions for paying fair compensation.
Okay, so that ensures some fairness, even while clawing back ill-gotten gains. Now, if the misconduct is serious enough, it moves beyond just the OC.
Correct. If the OC finds solid evidence of misconduct, they refer the whole case to the public prosecutor. The prosecutor then takes it to the appropriate specialized tribunal. The exact type of tribunal depends on who the leader is. There's one for the PM, another for the Chief Justice, and so on. They're specialized bodies.
And if that tribunal finds the leader guilty, what happens then?
The tribunal itself doesn't actually impose the final punishment. It makes a recommendation to the appropriate authority, basically. Whoever has the constitutional power to remove that official, that the leader be dismissed from office or position or face some other allowed penalty. The ultimate power of removal rests with the appointing body, acting on the tribunal's finding.
Right. But before that final judgment, there's that slightly contentious detail about the leader's status during the tribunal proceedings. They get suspended, but on full pay. To some, that might sound like a paid vacation for someone accused of serious wrongdoing. What's the rationale there? What's the law trying to balance?
That's Section 28. It automatically suspends the person from their duties as soon as the case is referred to the tribunal. But yes, it specifies the suspension is on full pay. The thinking here seems to be twofold. First, it immediately gets the accused leader away from the levers of power and influence while their conduct is being judged. That's crucial.
Okay, removes the immediate risk.
Exactly. Second, keeping them on full pay upholds the principle of innocent until proven guilty. It ensures due process and protects their livelihood from accusations that might, in the end, turn out to be unfounded. It prevents the process itself from becoming the punishment before a final decision is made.
So it's a pragmatic compromise, then. Prioritize getting them out of the office while the investigation is live, but protect their basic rights until guilt is formally established.
Exactly. It's a balancing act.
So, looking back at the whole structure of this organic law, it really is a system built on, first, incredibly comprehensive disclosure, demanding full transparency from the leader and their close associates. Second, a very firm firewall strictly separating public office from private business dealings. And third, a powerful enforcement body, the OC, armed with tools ranging from demanding detailed financial accounts all the way to ordering the forfeiture of prohibited assets.
Fundamentally, it forces ethical considerations to override financial opportunities for those in power. The law isn't just focused on classic corruption like bribery or theft. It's really aimed at the potential for undue influence that can come from family ties, associates, or business interests. It's a system designed, you could say, to eliminate financial conflicts of interest before they even get a chance to take root.
And for our final thought today, we have to touch on just how long the reach of this law is. You might think, okay, accountability ends when the leader leaves office. But this system actually tries to prevent them from immediately cashing in on their public service and influence.
That's right. The anti-corruption oversight doesn't just stop when they walk out the door.
Section 35 lays it out. A person is actually guilty of an offense if, within 3 years of leaving office as a leader, they accept a directorship, a consultancy, or certain other positions with a foreign enterprise without getting prior written approval from the OC.
Mm-hmm.
That 3-year cooling-off period is fascinating, isn't it? It suggests that the official oversight, the potential for scrutiny, doesn't end with the job title. The potential to exploit past influence is regulated for a significant time afterwards. It really underscores just how seriously this whole legal framework takes the concept of public integrity. Definitely something to mull over.